U.S. Supreme Court has overturned the ruling in Roe v. Wade that constitutionally protected abortion care. A woman's right to have an abortion through the first trimester of pregnancy was protected in the U.S. Supreme Court's 1973 landmark Roe v. Wade ruling. Plaintiff Jane Roe, later identified as Norma McCorvey, was an unmarried pregnant woman who was unable to get an abortion under Texas law, where it was illegal unless to save the life of the mother. Roe's lawyers argued against Texas District Attorney Henry Wade that the law was too vague and infringed her constitutional rights. In a 7-2 ruling, the Supreme Court agreed, ruling that Texas law infringed on a woman's right to privacy, was overly broad, and violated the Constitution's 14th Amendment. Following the Roe decision in 1973, states have enabled a patchwork system of legal care. But even with Roe in place, abortion patients throughout the South and Midwest have faced other restrictions that make abortion care difficult to access. These include mandatory counseling and ultrasounds before an abortion, waiting periods, and restrictions on healthcare insurance. Conservative movements in the U.S. have spent decades trying to overturn the decision, despite polls showing strong support for abortion care across America.
Your baby is not a mistake. Your baby's a gift from God.
In 2018, Mississippi's Republican-dominated state legislature banned abortion after the 15th week of pregnancy. The last remaining abortion clinic in the state challenged the law, bringing the case to the Supreme Court. A leaked draft of the Supreme Court judgment on the Mississippi case was published by Politico in early May. It indicated that the Supreme Court would rule that Roe and Casey must be overruled. Reacting to the leak, Democrats initiated a vote to codify abortion protections on a national level. The vote failed, with every Republican voting against advancing the legislation. The Supreme Court has overturned the landmark ruling, leaving the country without federal protections for abortion care. Without these protections, more than half the U.S. will move to outlaw abortion care. With Roe no longer in place, 13 states have so-called trigger laws that will kick in, making abortion illegal. 12 states will make abortion care a felony crime, with prison sentences or heavy fines against providers. 10 states make no exception for abortion access, even in the case of rape or incest. Some states have passed laws banning abortion at 6 weeks, before many women even know they are pregnant. Patients in the Deep South will have to travel the farthest to a state that allows abortion. The median distance people will have to travel for abortion access could more than double, from around 40 miles to more than 100. From New Orleans, a patient would have to travel more than 900 miles to Illinois or 1,400 miles to Colorado, the nearest states where abortion care is protected. Black women are likely to experience the most dramatic increase in distance to care, followed by Hispanic women and those living in poverty. States with the most severe restrictions are also some of the hardest places to raise a family, especially for the poor. Patients have limited access to OB/GYN doctors, birth centers, and other maternal health care. Mississippi, who brought the case to the Supreme Court, has the nation's largest share of children living in poverty and babies with low birth weights, according to the CDC.